This online presentation has to do with the relationship between justice and rights. In the previous presentation, we have shown that there's a close relationship between the idea of justice and our commitment to human equality. In this presentation, we want to look at the relationship between justice and the language of rights. There's a very close relationship between the two. Indeed, we often talk about justice using the language of rights or making claims that people have certain rights. This is particularly true when we are thinking about what are called universal or human rights. But not all rights are universal or human rights. And so we need to begin first simply by thinking what we mean by claiming somebody has something as a matter of right, or they have a right to something in a general sort of way. To say that someone has a right to something is to say that that person has a legitimate expectation or a justified claim with respect to their treatment by others. To have a right means that one can justifiably expect and demand the types of treatment appropriate to the right. Another way to say this is to say that rights generate or point to obligations or a set of obligations that someone else has because you have the right. Thus, it is often said that a person's rights are rights held against someone else. That is to say, they point to someone else's obligations and duties in relation to you. Those obligations that others have in relation to you because you have a right, or that I have in relation to you because you have a right, may be either negative or positive, just as we've seen in relation or in comparing the principle of non-maleficence with the principle of beneficence. A negative right is one that generates negative duties. That is to say, a negative right requires me not to do something, whereas a positive right requires me to actually do something on behalf of the one who holds the right.
Here's the way philosopher Joel Feinberg puts the matter. A positive right is a right to other person's positive actions. A negative right is a right to other person's omissions or forbearances. For every positive right I have, someone else has a duty to do something. For every negative right I have, someone else has a duty to refrain from doing something. This chart shows the relationship between negative and positive rights, and maybe most significant are the examples at the bottom. The right to free speech or to publish one's views. Those are generally considered negative rights. What they mean is you may not interfere with my saying what I want to say or my publishing what I want to publish. On the other hand, we're going to spend a lot of time later in the course talking about a right to health care. That would be a positive right. If there is a right to health care, or if we choose to recognize the validity of a right to health care, that would mean that someone, probably all of us through society or government, have a responsibility to act to make sure that people can have access to health care. Freedom of speech, a negative right. A right to health care, a positive one.
To this point in the course, we have focused our discussion on principles, and we have used those principles to think about what our obligations to each other are. Of course, we could also speak about rights to identify our obligations to each other, and we have sometimes spoken of rights. Think about the principle of non-maleficence. I related it to a right to life. The principle of non-maleficence suggests it's prima facie wrong to kill. But that would be to violate our right to life. In that respect, and what this illustrates is that principles and rights often do the same work for us. That is to say, they are ways we talk about the obligations that human beings have to each other. However, it's important to recognize that their focus is different. Principles focus on the obligations that the person acting has toward those affected by his or her action. The principle of non-maleficence, for example, points to my prima facie obligation not to kill. Rights, however, focus on the one acted upon or the one affected by actions. In thinking about my obligations to you, I could think about what principles I'm bound to obey, but I could also think about what rights you have, because those two generate the same obligations for me.
So here's the point. If our focus is on the person acting, our question is, what principles tell that person what to do? What principles identify their obligations toward others? But if our focus is on the one affected by action, our question is, what rights does he or she have? In both cases, the obligations of the actor are being identified, but principles focus on the actor. Rights focus on the one acted upon.
Having a right does not mean that it is morally right or justified for you to exercise that right in any particular way. Remember, if you have a right, that means other folks have an obligation. If we are deciding what someone should do, the rights of others are relevant, but their own rights are irrelevant. Let's make this personal. I have a right to free speech, so do you. That does not mean that anything you or I might say is morally justified or right. What it means is other people may not interfere with us, even if we should choose to say something that was wrong, like something that was scandalous about another person that wasn't true. So if I were to say something truly evil or to speak an obvious lie and you said to me that was wrong, it would be meaningless for me to say, no, it wasn't. I have a right to free speech. My right to free speech means you can't interfere with my speaking my mind. But it doesn't mean you can't tell me that what I've said is wrong, or in no way provides a justification for the idea that what I said was right. You have a right to associate with anyone you want to. That means you or others, me, the government, cannot keep you from forming friendships with whomever you want or for joining any organization you want. But that does not mean you're deciding to join a white supremacist organization, for example, the Ku Klux Klan, is the right thing to do. You have the right to do that, but we still might think it's wrong for you to do it. So let me summarize briefly what I've been saying. Having a right does not mean one is obligated or even permitted to exercise that right in any particular way. If we are deciding what someone should do, it's only the rights of others that are relevant and the principles that are applicable to that person's action. And an appeal to your rights does nothing to justify your action. An appeal to your rights only says what others may or may not do.
At the beginning of this presentation, I suggested a close relationship between rights and the principle of justice. We often speak of justice using the language of rights. Given that the principle of justice has primarily to do with institutions, particularly institutions like the government, and the legal structures it puts in place and enforces, we typically invoke rights when we are trying to say something about the responsibilities of government. You might recall Jefferson's claim in the Declaration of Independence that the very purpose of government is to protect people's rights. So, for example, when those who talk about a right to life are typically pointing to the government's responsibility to pass laws that protect those from being killed who have a right to life. The right to life movement is working to get the government to declare abortion as illegal, overturning the Roe v. Wade decision, for example. It's also important to recognize that when we invoke the language of rights, we are intending to protect ourselves from government. Given their power, governments themselves may represent the greatest potential threat to us and to our rights. As a result, we use the language of rights to point to claims we make against governments. When we talk about rights, we are typically pointing to obligations that governments have first for guiding their own conduct in relation to us, and only secondly to put in place measures that assure that individuals and other non-governmental institutions meet their obligations to us related to the rights in question. This relationship between rights and the attempt to make claims about the responsibilities of government may also have to do with the observation that moral claims made by an appeal to rights are typically meant to be especially strong ones. Alan Buchanan has written this: "To say that a person A has a right to something X is to say that A is entitled to X, that X is due to him or her," unquote. Such a claim is stronger, he suggests, than simply saying that A ought to have X, or that it would be good if A had X. Stronger even than saying that a society capable of providing X is morally deficient if it didn't do so. Buchanan says that rights claims override appeals to utility. This means that just because some policy promotes human welfare, makes people better off, a policy that would seem to be required of us because of the principle of beneficence, if that policy involves violations of people's rights, then it would be unjust. Here we would have a classic conflict between beneficence and justice.
Probably the most significant reason for the idea that there's a close connection between the language of rights and the principle of justice has to do with the fact that when we talk of rights, we're often talking of what are called universal or human rights. Consider this definition of rights from the Oxford Companion to Philosophy. They say that rights are justified claims to the protection of persons' important interests owed to persons for their own sakes and essential to human dignity. We often refer to things as rights, which we think people have simply because they are human beings. And those rights protect aspects of what it means to be human that are essential to our dignity. Now, not all rights are human rights. Not all rights are universal rights. We have some rights not because we are human beings, but because of particular agreements or relationships that we have with others. For example, if you sign a contract, you generate rights and responsibilities for all the parties involved. Spouses may be said to have particular rights in relation to each other, and children rights against their parents. Even the rights that all citizens have in a particular society because of an implicit social contract thought to bind all together in a shared national community, or rights that one may be thought to have because of the unique contributions or sacrifices you have made for that society. Those are different still, even from what are called universal or natural rights, rights that one or human rights, rights that one has simply because one is a human being.
Consider these four characteristics that philosopher Richard Wasserstrom has identified as distinguishing general or human rights from specific rights. First, he says, a universal right must be possessed by all human beings as well as only by human beings. Second, because it's the same right that all human beings possess, it must be possessed equally by all human beings. Third, because human rights are possessed by all human beings, we can rule out as possible candidates any of those rights which one might have in virtue of occupying any particular status or relationship, such as that of a parent, president, or promisee. And fourth, if there are any human rights, they have the additional characteristic of being assertable in a manner of speaking against the world.
Rights of the sort that Wasserstrom has in mind are often thought of as natural rights. By that I mean they are rights that are thought to be derived from certain essential facts about the way things are, or especially about the way we are as human beings. Natural rights, then, are thought to be derived from the essential characteristics of human nature that philosophers have identified. This way of thinking about rights is consistent with the reasoning we have discussed behind the principles of non-maleficence, beneficence, and autonomy. Think first about our discussion of the principle of autonomy, the idea that we have a prima facie obligation to let other people exercise their capacity for self-rule by not coercing or manipulating them. I suggested that the fundamental reason we have come to recognize such a principle is that we have come to regard our autonomous nature, that nature that all human beings seem to have, as an essential aspect of what we are and who we are as human beings. Our capacity for self-awareness, for self-transcendence, enables us to distance ourselves from the way we are influenced by physical stimuli and even the influence of our culture, and decide for ourselves how we will act in any particular situation. What values, what goals, what purposes will guide our action. Our autonomous nature enables us to reflect on the meaning of our lives and enables us to choose meaning and purpose we will seek in our lives. Some have argued that this autonomous capacity is what makes us moral creatures, such that in its absence it's impossible to imagine what it would even mean to say that someone had a moral obligation or moral responsibility. Now, if such a characteristic is so significant to what it means to be a human being, then we surely owe each other respect for the exercise of this autonomous capacity. Moreover, when we turn then to the idea of rights derived from or related to this aspect of our nature, we are pointing to the responsibility that governments have both to honor our autonomy themselves and to put in place measures that protect us from violations of autonomy. Some of the most basic rights identified in the Bill of Rights, amended to the U.S. Constitution, and in the Universal Declaration of Human Rights, could be understood as related to our autonomous capacity. So the rights that protect our freedom of religion, our freedom to decide for ourselves what basic beliefs about God and the origin of the universe and moral obligation are. Freedom to decide for ourselves about those matters, what we will believe and how we will practice those beliefs. Freedom of thought, freedom of speech and press, to be able to share our thoughts. All of those fundamental freedoms, those fundamental rights, could be seen as derived from a recognition of the significance of our autonomous capacities. Recall our discussion of the social nature that is part of the background to the principle of beneficence. I said there that alongside our autonomous capacity, another truth about us seems to be that we are dependent upon others for survival, for culture, for language, also dependent upon others in the sense that the most significant meaning and purpose that we find in our lives is often related to our families, our friendships, our intimate relationships, the communities of which we are a part. If all that is true about us, if we have a social nature, that means we should recognize rights of association, rights to marry whomever we choose, rights to participate politically. All of those fundamental rights could be seen as derived from or related to the fact that all human beings seem to have a social nature. So that if you are going to honor a human being, if you are going to respect human dignity, one must respect this human need to unite with others, to form friendships, partnerships, associations with others. You will recall our discussion of the physical nature that provides a background to the principle of non-maleficence. Recall the insistence that in fact human beings are beings who live in and have bodies that are equally vulnerable to injury and to harm, to death. And that is a basis for the principle of non-maleficence. As we turn to rights, we can see the affirmation of rights to physical security. I would say even an affirmation of rights to property as related to this recognition of our physical nature. Of course, as I've said many times, we're going to be considering later in the course the idea of a right to health care, which alongside other similar sorts of rights, rights to food, rights to shelter, right to clothing, which is affirmed, if not in our Bill of Rights, certainly it is in the Universal Declaration of Human Rights. One could see all of those as derived from, grounded in, justified by a recognition of our physical nature as human beings, the reality of beings who have bodies that require sustenance, that are vulnerable to illness and injury.
To summarize what we've said here, we often talk about justice in the language of rights. We do so because rights are thought to be a language appropriate to the strongest sorts of claims we want to make. Claims that particularly we want to hold over against governments. Claims that point to a government's responsibility both to respect our rights and dignity as human beings and to enforce respect for those rights. That's especially the case when we're talking about natural rights or human rights. Rights derived from those fundamental aspects of our nature, like our capacity for autonomy, our need for other people and to form associations with other people, and finally, the reality that we have bodies that are vulnerable to illness and injury. These are often the basis for our most fundamental human rights that define justice for us.